Thank you for watching Brindley and Mesa's Pecha Kucha presentation on the New Jersey versus TLO case of 1985 for our school law class. This case addresses Fourth Amendment rights and its relevance. Today we will be discussing the importance of this case, the history behind it, and the impact it has had on schools when conducting search and seizure protocol. The New Jersey versus TLO case was set in 1985 at a high school in New Jersey. On March 7th of 1980, a teacher in Piscataqua High School in Middlesex County, New Jersey, caught two girls smoking in the school lavatory. Piscataqua High School is a four-year high school located in southwest New Jersey. This case addressed the Fourth Amendment, which states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." There were two parties involved in this case, a 14-year-old freshman, TLO, or Tracy Lois Odom, and the assistant vice principal. The vice principal, Theodore Choplick, conducted the search on TLO's purse. After the confession from the other girl in the bathroom, the state of New Jersey decided to press charges against TLO for selling marijuana and smoking in the school bathroom. The case was granted certiorari because they wanted to examine the effectiveness of carrying out searches in school due to the Fourth Amendment. Granting certiorari is a writ of order when the court decides to review a case. In order to grant certiorari, at least 4 justices must vote in favor of hearing and reviewing the case. This case started when 2 girls were caught smoking in the bathroom by one of the teachers. Smoking in the bathroom was a violation of school rules, so the teacher proceeded to take the girls to the office. The vice principal began questioning the 2 girls. Soon, TLO's companion admitted she had broken the rules and smoked, while TLO denied that she was smoking and claimed she had not been smoking at all. After Mr. Choplick questioned both girls, he asked TLO to come into his office, where he then demanded to look inside her purse. After Mr. Choplick opened the purse, he found a pack of cigarettes, rolling papers, marijuana, a wad of cash, a pipe, plastic bags, and an index which was a list of students who owed TLO money. After his findings, he notified the police and TLO's mother. Once TLO's mother found out, she took her to the police station where TLO confessed to selling marijuana at the high school. Once TLO was convicted of her delinquency charges in juvenile and domestics court of Middlesex County, she argued the evidence, and her confession was due to Mr. Choplick's unlawful search and a violation of Fourth Amendment rights. After reviewing TLO's statement, the court decided that school officials may conduct searches of personal belongings due to reasonable suspicion that the crime has been or is in the process of being committed. The search can also be conducted if the school official believes that it is necessary to maintain school discipline or enforce school policies. After the juvenile court ruled that the search was reasonable, TLO took her case to the New Jersey Supreme Court. The Supreme Court ruled that the search was unreasonable and the evidence could not be used and had to be thrown out. Therefore, the decision was appealed and the case was brought to the United States Supreme Court and was determined by them. In a 6-3 decision for New Jersey with the majority opinion by Byron R. White, the court ruled the search was reasonable due to the discoveries. Mr. Choplick had reasonable suspicion because the friend of TLO admitted to smoking in the bathroom. Berger, White, Blackmun, Powell, Rehnquist, and O'Connor voted for reasonable cause, where Brenna, Marshall, and Stevens did not vote in favor of the ruling. While the Fourth Amendment's prohibition of unreasonable searches and seizures applies to public school officials, they can conduct reasonable searches of students without a warrant under their authority in spite of the probable cause standard that would normally apply to searches under the Fourth Amendment rights. Reasonable suspicion requires less knowledge than a probable cause and exists where the facts and circumstances known to a school official raise a moderate chance of finding evidence of wrongdoing. Even an anonymous tip can provide reasonable suspicion for a search if the source is sufficiently reliable. In TLO's case, the teacher was provided reasonable suspicion. Probable cause is found in the Fourth Amendment. It must be met before police officers can make arrests, conduct searches, or receive warrants from court officials. Typically, courts find probable cause when there is some suspicion of a crime being committed. Only under urgent circumstances can probable cause justify a warrantless search and seizure. Teachers and school officials have the right to search students' belongings without obtaining a warrant. This is because students are under the authority of school officials. School officials do not need to have probable cause to search, but can search belongings strictly off reasonable suspicion. Students in schools have limited access to privacy because of this. In order to determine whether searches are reasonable or unreasonable, there must be a reasonable suspicion to conduct the search. School and public officials must have probable cause to conduct a search by obtaining a warrant from a judge, or the search may be deemed reasonable if the circumstances justify the search and therefore the warrant isn't needed. Minors have rights similar to adults but may not be tried as an adult and are tried as a juvenile, like TLO. Some legal rights are that children are entitled to a safe environment, good nutrition, health care, education, due process, equal protection no matter race, gender, religion, or disability, and Fourth Amendment rights. One case that is similar is Bethel School District number 403 versus Frazier. This case also dealt with the Fourth Amendment and is listed as students in school only enjoy a limited expectation of privacy and are not automatically entitled to the same protections under Fourth Amendment rights as adults are in other settings. Another case is Safford USD number 1 versus Reading. A school administrator's search of a student's backpack and outer clothing for prescription drugs was legal, but a search of the student's underwear was intrusive and unreasonable. Since the administrator had no reasonable suspicion that the student had also used her underwear for hiding of evidence or that the circumstance posed any danger. Thank you for watching our presentation on the 1985 New Jersey versus TLO case. It is extremely important to remember the Fourth Amendment rights and how it has impacted schools. Students' privacy laws change the moment they walk through the school doors, and it is the job of school officials to enforce school rules and policies while presenting them in good faith.